Assalamualaikum and very good morning. So today I'm going to record IRAC principles. That will be useful for you to answer law paper. So what is IRAC? IRAC here is the most simplest and systematic way of answering problem-based question. So there are many types. There are many ways of answering law paper. But IRAC is the most systematic and the most simplest way for you to use. So you only use IRAC when it comes to problem-based question. So for PBQ, you don't use IRAC for essay type. For essay type, you just simply use the essay like you have been taught in school. For example, like you have introduction, and then in the discussion you discuss, and then you argue against, or you support the statement or whatsoever, and then what is your own opinion, and then you end with conclusion. That one is for essay type. So you have to know, the essay question versus PBQ. So, meaning that IRAC is only applicable to PBQ. This is an overview. What I'm going to discuss with you. I'm going to introduce you to IRAC, and then what is IRAC, how to use IRAC, and I will give you 2 PBQs. I will show you how to solve it, and then finally, there is 1 PBQ for you to do in your group, in your team, and we will discuss in the next class. As for introduction, students are asked to identify pertinent issues and apply the law to the facts in the question to reach a conclusion. When answering problem-based question, which is known as PBQs, using the IRAC approach, which are based on factual scenario. So IRAC is used by the legal fraternity, like even the lawyers, the judges, they use IRAC also in order for them to systematically analyze, analyze the legal issue before them. So it will also make your reader, for example, me as the examiner, to easily and systematically evaluate your legal analysis. IRAC here stands for I for issue, rules for, R is for rules, A is for application or analysis, and C is for conclusion. IRAC is not the only way to answer. Sometimes some people, they use IRAC, meaning that F is for facts, this one is for issue, this one is for law, this one is for application, and conclusion, similar. Some people, they use IRAC, issues, law, application, and conclusion. So it's just the same here, because before for us, we prefer to use this, we prefer to call the acronym as IRAC. So first you need to find the issue. Before you need to find the issue, obviously you have to read the facts. Then you wouldn't know how to find or how to determine the issue if you have not read the facts, So meaning that facts is meaning that it is understood that you have to read the facts, So it's issue. Issue means that you have to identify and state the legal issues involved in the question or involved in the issue, So you can use what, when, who, why, whether, how. Does it always have to be in question form? I suggest you should have it in question form. But having said that, there are many there are many scholars, okay, who say that you can even have in a statement. Well, meaning that so there's nothing wrong if you put in a statement. But to me, it might be difficult because if you put it in question form, it's easier for you to answer whether you have answered the questions or not. So it'd be easier for you to plan your answer. Okay. Then the rules. Okay, the rules comes in the form of statutes. Why I put N. Okay, and O. So sometimes you only have statutes only. Statutes means for employment law you have EA. Okay, you have Industrial Relations Act. Okay, the acronym is IRA. Or you have Trade Unions Act. The acronym is TUA. Or you have OSHA, Occupational Safety and Health Act. Okay, so you have Social Security. Okay, SOCSO Act. Okay, so these are the example of statutes. And you have cases. Cases means that cases that discuss employment law or anything. Okay, so but of course this discourse is on employment law, so the cases must discuss, okay, employment law. Sometimes you only have one case, a statute only, you do not have cases, then that's fine. Sometimes you only have cases but no statute, then that is also fine. But sometimes, okay, itu maksudnya we have statutes or cases, either one. Okay, but sometimes you have, instead of all, you have statute and supported by cases. Okay, so that's why the word here is and stroke all. Okay, next is application or analysis. So you need to analyze the rules and apply those rules to the issue. And finally, draw a conclusion from your preceding explanation, analysis, or arguments. Okay. So how to use IRAC principles? Okay, I showed you in the form of problem based. Okay, I show you how so that it will be easier for you to understand. Okay. So the fact is, Mamat, okay, a 50-year-old independent contractor from Malacca has been engaged for some construction work by the Lulus and Denver Hut. Mamat attends a number of staff meetings as well as a training course provided by the company. Mamat suffers an injury while performing his tasks at the Lulu's premise. Analyze the legal issue in this situation. So first, of course, you have to identify, you have to read the facts. So when we read the facts, the relevant facts here is Mamat is an independent contractor. Okay. And then Mamat is engaged to work with the Lulu. And Mamat attends staff meeting. Mamat attends training course. And then Mamat suffer injury. So now, does his age important here? No, it's not. Okay, it is not important. So you do not have to dwell on the age factor. Okay, now how are you going to okay, state your issue? So first, okay, when it comes to issue, okay, you have to identify the issues or problems that you are trying to answer. What are you going to discuss? Okay, so again, okay, so you has to be, it's good for you to write, okay, combining the relevant law and facts. Okay, so what the rules of thumb here is that you have to be very specific about the issues for each of the parties. Okay, so you have to know, yeah, is it for both parties, or are you advising the defendant, or are you advising the plaintiff? So you have to read the question carefully. So it is good to state the name of the parties to the legal issues. For example, who is the plaintiff or who is the defendant? Plaintiff is the one who commences the legal proceeding. Defendant is the one who defends, okay, the legal case. Therefore, okay, you have to name. For example, here we have, okay, so now it can be the Lulu, okay, the Lulu, the employer, and Plaintiff is this is okay, the Lulu, defendant, okay, and plaintiff, the one who taking action, could be Mamat. Okay, so here, can you just merely state, can Mamat sue the Lulu? So this is, I mean, not 100% wrong, but it is not not convincing enough. Why? Because it's very vague. Because remember, you have to include relevant law and facts. So that is why, I mean, I suggest that, okay, the issue should be written in such a way. Is Delulu liable to compensate Mamat for the, okay, injury suffered while performing his task? Okay, so here you can see already. So now Mamat is suing Delulu. So now the plaintiff, okay, the parties here is defendant. This is plaintiff. Okay, why is Mamat taking actions against Delulu? Because he suffered injury. When? While performing his task. So that is why, for me, this is a good suggestion, because it has the relevant law and also the facts. It's not vague as stated here. Okay, next we go to rules. What is rules? Rules here means, okay, you find the legal rules that apply to the issues which you have already identified. Okay, so the principle here is known as rule, or if you use IRAC, they call it law. So legal rule can comprise of legislation and case law, as I mentioned earlier on. Legislation here refers to statute. Sometimes you only have statute, you do not have case. Sometimes you only have case, do not have statute. Sometimes you have both. Okay, so you have to state the legal rules in general. Okay, and you don't give any conclusion to any particular case yet. You just mention the case and you just mention the statute, very general. Okay, so here, okay, so what you can say here, in order for you to understand, you have to go back to the slides on common law test to determine employer and employee, and also the contract of service and contract for service. Okay, so in these circumstances, okay, in order for you to understand whether the Lulu is liable or not, therefore you have to determine whether it's, because the Lulu is only liable if Mamat is the employee. Okay, or so meaning that is Mamat under contract of service or under contract for service. You know, some of you may say, but madam, earlier on it says independent contractor. Yes, it says independent contractor, but when you read further, okay, Mamat has to attend courses. Mamat has to attend staff meeting. So it shows that Delulu has control over Mamat. Okay, meaning that even though it is stated that Mamat has, okay, that Mamat is, okay, independent contractor, but the fact shows otherwise. Okay, so that is why, that is why you need to discuss the current common law test. Okay, in determining whether the worker is an employee under contract of service or not. So this is slide slide 5, slide 4. If I'm not mistaken, it's slide 4. Yeah. Okay, so you have to break down the relevant rules of law into the elements. Okay, so if there are sub-issues, then you make it in another paragraph. Okay, so if there are more than 2 issues, you settle first issue, IRAC for first issue, IRAC for second issue. Okay, so you must write, okay, the name or title of the act that you are applying. So now let's say you forgot the name of the act, but in your situation, there shouldn't be a case because you are allowed to bring anything under the sky for your exam. Next, we go to application. Okay, so you have to apply the rules. Okay, what is the rule? in order to the common law test, okay, whether Muhammad is an employee under contract of service or under contract for service. So you need to apply that. So application is a process of applying the rules to the issue. Okay, remember in the rules section, or the rules paragraph, you do not discuss in detail the law and the cases. You just mention the case and just mention, okay, the law, okay, the statute in general. So application is the most longest, okay, in your answer, and this is where the most marks are. So application is very crucial to improving that you comprehend how the law works in a given circumstances. Okay, bear in your mind, but sometimes there will be no right or wrong answer, but you have to be confident, okay, in answering, okay. And don't worry whether your answer differ from your friend, because it depends on how you argue. So when it comes to application, it involves explaining the relevance of the law to the factual situation. Our factual situation here is Mamat, who suffered the injury, and how it can be used by each party to argue their position. This is, you have to look at the question. If you are if you are law student, normally you have to argue from both. But if in your situation, you look at the question whether you are advised Mamat or advise the company. So you just okay, you just refer to the instruction, okay, and you need to consider law from each party. This one is normally for legal student, for law student, or non-law student. Again, if you are if you are required to advise the plaintiff, then from the plaintiff's point of view, okay, because we do not expect too much from the non-law student, okay. So here you present your supporting arguments, meaning that important facts, legal rulings, and outline how you plan to reach the conclusion. So you quote the precedent, the cases, if there is any. So here you have to consider, okay, when you quote the cases, it's good if you say that whether the situation here, is similar, or whether you are going to use that case to refute, okay, or to argue against. So it's up to you, okay. So meaning that you are distinguishing yourself from the case that you are referring to. So meaning that the case, okay, can be used to, okay, support, or you can refute the application. You can rebate, okay, can rebate. So not rebate, rebut. You can rebut, okay, the application of the case to your present issue. So here it will guide me as a reader, okay, whether you are on the right track, okay, whether, so I will know from here that you are on the right track, okay. So it is good for you to arrange your answer according, meaning that you have to, if the discussion is too long, then you have to break up into several paragraphs. Okay, then the application of law. Okay, so here, okay, what you can say is that Mamat company here requires Mamat to attend. So therefore, okay, here it shows that they have high level of control. So these are the factors here, okay, in slide 4, the test that you use, okay, the test, okay, and the factors here as laid out by ready-made. So you have to dwell on this. So it's very lengthy. Then how are you going to conclude? Okay, what is a conclusion? So you have to draw a conclusion from your preceding explanation, analysis, or argument. So in your conclusion, do not include something new. Do not include something new. So it has to be whatever that have been discussed in above paragraph. So actually there is no right or wrong answer, yeah. So you don't worry about that, okay, because it is in law, it's not like 1 + 1 = 2. Okay, so but you choose which is the most convincing, okay, that you would prefer to be as your conclusion. Okay, the most important that most important is we are going to look at whether you understand, okay, the process, okay, whether you understand the, whether you can argue, whether the legal reasoning is put forth in a clear manner, okay. So once you reach a conclusion, okay, so therefore, okay, for example, here you can look at this is example that I gave you. So your conclusion must be based on the evidence that you have discussed earlier on, meaning that the statutes, the cases. So you choose the argument that you think the strongest and articulate what you believe to be the appropriate advice. So now this is the example that I gave you. Okay, you do not write in this manner. Why? Because you must not say definitely, or this is very strong words, okay. You cannot assert a strong words. It's not, because here you just advise, okay, whether, okay, whether who is liable, whether the company is liable or not, it is the judge who makes the decision. So that is why it is suggested that you write in such a way. You can say that based on the above argument, it is highly likely that Dululu would be found liable. So here you can say, from here, you can say that, okay, Dululu can exercise control over. This is based on the facts that Dululu attended staff meetings. Dululu attended training, and this is based on the test as laid out by the case of ready mix. So, but you do not have to dwell the case anymore because you have done this in the application. Okay, so based on this, okay, Mamat can be regarded as an employee, okay, under contract of service, okay, due to the nature of his work. Therefore, it is very likely that Dululu would be found liable for Mamat's injury occurred at the company's premise. Okay, so now we will do it together. There are two PPQs that I have drafted here, or that I have created for us to do together. Okay, first, let's read the fact. Okay, I give you a few minutes for you to read the facts. Okay, Boboy, a 35-year-old 40-feet container lorry driver at Delicious Food Industries in Berhad, hereafter referred to as the FISB. So you do not have to write in full all the time. If you have put it in a bracket, then it's a subverb. Okay, if you do not want to even write as long as this, you can say that the FISB, just write. Okay, that is sufficient. So that you have indicated that the FISB here refers to Delicious Food Industries and Berhad. Okay, for the past 10 months. The FS, okay, so this is wrong, yeah. The FISB is located in Bandar Estak, Negeri Sembilan. Okay, he intends to end his service with immediate effect. So he pays the FISB a sum of 4,200 ringgit, which is equivalent to his 1 month's salary, as an indemnity in lieu of notice. However, the company contends that Boboy must surrender the notice, and it is insufficient by substituting the notice with money. So advise. So in these circumstances, you're advised whether, okay, it could be whether Boboy, okay, whether Boboy is allowed to pay indemnity of notice in, okay, so that he can leave immediately, or you can say that whether the company's contention that Boboy should render notice instead of money is correct. Okay, so the facts here, Boboy is the FISIB driver. So meaning that when and then where is it? It is in Bandar Estak. So why is this important? Because you have to determine whether EA is applicable. Bandar Estak is in Negeri Sembilan, so meaning that he is under the purview of Employment Act. Okay, what about his salary is 4,200. So when you refer to section first schedule says, okay, in the first schedule, it says that, okay, there are two categories. Okay, first is and the contract of service, and the salary is more than 4K. Okay, meaning that even though you are more than 4K, you are still entitled to under Employment Act, but there are certain provisions which are not applicable to those who earn 4,000. However, there is the second limb is whereby, okay, second category, there are 5 types of employees. Manual labor, manual, and then okay, those who are involved in the okay vehicle for transportation of goods or okay or people. So boy falls here. Okay, boy falls here. Okay, and then this is supervisor to manual laborers. This is those who work in vessel, and this domestic employee. So boy is here. So meaning that it does not matter whether boy earns 4,200, he's still under Employment Act. So you need to argue that in the when you okay in your answer. And then now the fact is, okay, can boy submit? Can boy just pay okay amount equivalent to his 1 month's notice? Okay, so now his age is not material here. So now let's look at here. Okay, when you have more than one issue, so you need to do IRAC for both issues, one by one. Okay, more than one issue. So you need to do IRAC for number 1 and then IRAC for number 2. Okay, IRAC for number 2. So now in the, okay, actually you do not have to write like this, because this is just for you, okay, just to try to imagine, okay, but you do not have, in the exam, do not have to write like, okay, do not have to write rules, application, and so what is the rules here? Remember what is, okay, the rule is you have to find what is the law, okay, what is the issue in, okay, here, issue means problem, so you, okay, you can have it, remember, you must have law, relevant law, and facts. So here I can say that whether the company is right, or you can say whether the company's contention, okay, in refuting Boboi's rights to pay the company a sum equivalent to his termination notice is correct. Or you can say whether Boboy can leave the company by paying an indemnity in lieu of notice. So, or you can even have any other sentences as long as it has similar meanings, meaning that leave the company, pay money. Okay, that is okay. So in the next paragraph will be, now you have to identify the issues. So now you are so now the first one is that you need to identify whether, okay, you need to identify employee. Who is an employee? Okay, so the submission would be whether Bobo is an employee. You don't have to answer here yet because you need to answer in the application. And then why is the law concerning notice period? Okay, the law. So you have to state generally. The law says that, okay, the length of notice shall be determined by the terms of employment, section 12(1). And in the absence of such notice, in the absence of an agreed notice period, therefore section 12 sub 2A until C is applicable. So meaning that here, okay, so meaning here, section 12 sub 2 sub A until C is applicable depending on the employee's length of service. And then you generally mention about section 13. An employee may pay the employer indemnity in lieu of notice if he wants, okay, to leave immediately, or employee, okay, submits the notice but do not wait for the notice to expire. Therefore, the employee must pay, okay, the employer the amount of the unexpired notice, the remaining amount. So let's say if he serves, okay, he serves one notice, but only work for 1 week. Therefore, he has to pay the company 3 weeks notice indemnity. Okay, So then how are you going to apply? So the application will be long. So first you have to explain whether boy falls under the first shadow. So which one category? So you explain the law, then you apply to boy. Next, you explain, you have explain about length of notice. You explain that section 12 sub 1 provides that, okay, there must be the agreed termination notice. Okay, so and then when you check the facts, it shows that, okay, boy has to give 1 month's notice. So meaning that section 12 sub 2 A until C is not applicable to boy, because boy has an agreed notice period that is 1 month. Therefore, but now boy would like to leave immediately. So so you cite the section first. Based on section 13, boy can leave immediately provided that he pays an equivalent amount of the notice. So meaning that if boy leaves immediately, boy wants to leave immediately, therefore boy must give 1 month's notice, the salary which is equivalent to 1 month's notice. So meaning that 4,200. Or boy, that is under section 13. Or boy, so in these circumstances, so then you conclude. So here you can say that the company shall not refute boy's right, because boy has paid the company 1 month's notice, being an indemnity in lieu of notice. So as what stated by the contract of service. So that's all for boy. Next, example number 2. PBQ number 2. I'll give you a few minutes for you to read the facts. So, Marcona, famously known as Macarena, works as a receptionist at Jaiho, since March 2023. She is being paid 2,000 per month. She intends to celebrate the Hari Raya Aidilfitri 2024, scheduled on 10th April at a grand scale. Therefore, she plans to utilize all her annual leave for the Hari Raya celebration. Upon checking her terms, she finds out that she is entitled to 7 days annual leave per annum upon the completion of 12 months continuous service with the same employer. She will then be entitled to 14 days annual leave from her 3rd year of continuous service with Jaiho Sendian Berhad. So Macarena is unsure whether she is accorded the rights according to the Employment Act. So you are required to advise Macarena. So the issue here would be whether Jaiho has committed any non-compliance when the paid annual leave or annual holidays stated in Macarena's terms of employment do not conform the provision of EA. So this is where, I have already put the law and the facts. The law here is, you have, paid annual leave and Employment Act. But here, the fact here is, it does not conform. So, it's very clear. When I, as an examiner, when I read, I know that, you're on the right track. So for rules, as I said, rules can only, rules is in, you just mentioned general rules. First, the sub-issue is you have to define, So first you have to, mention that, only employee is governed by Employment Act. Then you provide that, when it comes to annual leave, Section 61A, until C is applicable. However, less favorable terms shall be void and more favorable terms will be substituted, therefore. That is Section 7. However, based on Section 7A, more favorable terms are not prohibited. That is Section 7A. Now you're going to apply. So you apply. So when you discuss, this one, then you will conclude that Macarena falls within the definition of first shadow. Now you are going to discuss whether whether company is committed any breach or not. Okay, because under section 60 E1A, okay, it has to be okay. So you have to cite this one. Okay, 8 days annual leave. But see, Macarena works from 1st March. So meaning that 1 year service is, 28 February, 1 year. So meaning that she is entitled to the first year annual leave in her 2nd year. Okay, so that is why the Hari Raya is on 10 April. She wanted to apply all the 7 days. So now the question is whether 7 days is correct. So obviously it is against section 61A because section 61A provides for 8 days. Therefore, this is less favorable. Okay, so when it comes to less favorable terms, it shall be void. Okay, and the provision in the Employment Act will be substituted thereof. So meaning that Macarena, so now you apply. So now Macarena is entitled to 8 days paid annual leave, not 7. So the company has committed a breach here. Okay, so here, what about, this is actually the main issue is on annual leave. So there are 2 issues here, 2 sub-issues. So, the second sub-issue would be, can the company provide 14 days instead of 12 days? Okay, so here you can say that based on, so you start to discuss that based on section 60E1 sub B, employee is entitled to 12 days on, 12 days or upon, on second, when she works 2 years and above. Okay, meaning that 1 to 2 years is 8 days. Okay, then second year, 3rd year onwards, it is 12 days. But now the company is giving 14 days. So meaning that it does not conform EA, but it is more favorable terms. Therefore, by virtue of section 7A, more favorable terms are not prohibited. So in these circumstances, you can say that Jaiho does not commit any breach. As it's stated there. Therefore, Macarena is entitled to 14 days annual leave on her 3rd year of continuous service onwards. So how you conclude? So you conclude by mentioning the breach and also the 14 days annual leave. So that is how you answer. So meaning that it depends on how well you can explain. So again, don't worry about your grammar. I'm not going to check your grammar. But I want you to express yourself here. So this is the question that I want you to do on your own. With your team. And then we discuss in the class. We will discuss together. So this will be like, 2, 3. This is the 4th PBQ. Or we did Suzy, so this is the 5th already, yeah? So try and do it. So it does not matter if you got it wrong, we do it together in the next class. So to conclude my lecture today, so I have already explained to you the IRAC principles. Why we use IRAC? Because we can answer systematically, so easier for you as a student and easier for me as an examiner. And IRAC is not only used in class, it is used by the lawyers, by the judges as well. Then I explain to you what IRAC here means, and I give you an example of Mamat versus Dilulu, and I also give you an example of Macarena versus Jaiho, how you should dwell on that and so forth. Then you are required to do the PBQ on Aaron with your team, which shall be discussed in our next class. So with that, I thank you.